you test drove the car. And
I did test drive the car.
You did indicate that you became aware of a knock on the engine. He didn't deny that.
That wasn't before.
No. He heard the knock when he inspected the vehicle, and I told him exactly how it went away, and he was content and satisfied with how the vehicle was.
No.
Let's go further. You then take the car and you raise all of these issues to the defendant, and you say you want your money back. And he's refused to give you your money back, yet he gives you a $300 refund, and you accepted that.
Of course, yeah.
And there is this principle in the law called accord and satisfaction. And that means that if you have a dispute with someone and you take money and accept that, the law can presume that that was the deal. That becomes a new deal.
Right.
That you're taking the car now, again, with all of these potential problems because you're getting it for $300 less. Also, you represented in your papers that the defendant told you that the car was in excellent condition.
Actually,
Did he actually use the word excellent condition?
I believe so.
I don't see him using the words excellent. I see him using kind of genuine,
We
ambiguous.
spoke about it being in excellent condition because when we looked up the Kelley Blue Book value, he said that it matches the excellent condition, which is why he thinks that his truck was fairly priced.
Is that right?
We never discussed with the Kelley Blue Book how it matched on its
Did you ever
condition.
use the word excellent?
No, he actually used excellent. It was his words on page 8 of my evidence.
What does he say?
He says, I'll admit the truck is nice looking and seems really taken care of, but since it's the basic model of this truck, it only blue books at around $4,000 in excellent condition. So that was his.
So we did mention Kelley Blue Book.
Okay, we're going to excuse you while we deliberate in this case. Thank you.
Thank you.
Okay,
This
thank you.
courtroom is now in recess. I think both litigants came off very credible. I believe that they believe what they're saying.
Yeah.
I'm more inclined to believe the defendant here, that this was an as-is sale, that his listing wasn't misleading. And honestly, if you're buying a used car from a private party and they tell you that this car is in mint condition, will run for years, they've rebuilt the engine, whatever, you still cannot take the word of that private party. You got to get the stuff in writing. It's all in the details in terms of what the buyer is entitled to, their legal rights. And he just hasn't proven that the defendant was aware of these issues at the time of the sale. I'm not convinced.
And of course, the car is a 21-year-old car.
Yeah.
So it's going to have things wrong with it.
Right.
He did get that $300 refund. There's nothing here that would lead me to believe that he suppressed any of the evidence. I'm inclined to agree with you.
Yeah, the only thing that troubles me here is that the first time I feel like we heard anything about saying that repairs were needed before the alignment was done was kind of when I raised the issue. Well, wait a minute. They said substantial repairs would be needed before an alignment. On the other hand, I have a real credibility issue with the plaintiff. First of all, asking for essentially more than the car is worth in damages. And he has 3 different alternatives given for a transmission. The low end of the estimate is only $2,400 as opposed to over $4,000. And he's in here asking for a brand new transmission on a now almost 22-year-old car.
With something like that, I think we would have to believe that the defendant defrauded him. And
No doubt.
Bottom line is, I
That's
don't see
more
any effort to defraud.
That's the issue, and it was answered for me. I don't believe that the defendant was being misleading when he sold him this vehicle. And when you have a private sale, it is as is, period.
Yeah.
So I think we're all
We have a
in
verdict
agreement.
then.
You've persuaded me.
So
On
So
the
we
fence.
have a unanimous
the unanimous verdict.
do.
The
All right.
plaintiff failed to meet his burden.